afternoon and welcome to the Financial Empowerment Network Virtual Learning Series. Our training today is about medical debt in Washington State. The webinar audience is intended for professionals in the field whom we define as case managers, advocates, and financial counselors coaches to guide and contextualize the needs of your clients. The Financial Empowerment Network envisions communities where low and moderate income individuals and families are able to achieve financial well-being. Our mission, we advance financial empowerment through partnerships that support access to affordable, effective, and relevant services, products, and other resources. Our process is to serve as a liaison and broker to create connections, disseminate evidence-based and promising practices, and bring resources to a network of providers to integrate financial empowerment into other services, including anti-poverty strategies. With me today is Julia Kellison, a consumer attorney in Northwest Justice Project Seattle office. Her consumer practice includes representing victims of debt collection abuses involving medical debt, garnishment, predatory lending and student loans, and auto sales. Julia is on the executive committee of the Washington State Bar Association's Antitrust and Consumer Protection and Unfair Business Practice section. Julia received her JD in 1998 from Temple University School of Law and her BA in 1990 from Brown University. Please join Julia for an hour on medical debt and how we can help our clients get help with medical debt in Washington State, understand debtors' rights, and how to deal with collection agencies. Thank you so much, Julia, for joining me today to facilitate this training. And again, welcome everyone.
Thanks for having me here, Alice.
Absolutely.
And, just want to say, for those that don't know, Northwest Justice Project is a statewide civil legal services organization serving low-income people across the state of Washington out of multiple offices and through our statewide clear intake line. I'll talk more about how to reach NJP at the end with some other community resources. And one thing I want to emphasize is Washington Law Help, which is a website that has lots of organizations, self-help publications on it, is a really terrific resource, particularly in the area of charity care and medical debt. But in COVID, there are all kinds of great updated publications on rights and good information on benefits, landlord-tenant, family law, consumer law, which is what I practice. So I'm going to talk a lot about publications on Washington Law Help. I use it all the time. It's written for non-attorneys. There's self-help materials, sample letters. It's really a terrific resource, so use it. All right, and talking about medical debt, as many of you may have seen, the Washington State Supreme Court in 2015 did an update to its civil legal needs study, and the update showed that healthcare and consumer and credit issues were the top two most prevalent problems that people experience without a lawyer, which is certainly something we see borne out in the cases we see across the state and in our weekly debt clinic that we run in King County. It's a remote debt clinic, and I'll talk about how to access that at the end. Unfortunately, fortunately, we have really terrific state law on charity care or financial assistance, which is what we're going to talk about today, but not enough people know about it. So really important to get the word out. The law has changed in the last few years to require more notice for hospitals and debt collectors to let people know about charity care rights. There just aren't enough low-income patients getting charity care that they should be getting under our really terrific Washington law on charity care. We see low-income patients sued for hospital bills they shouldn't have ever received in the first place. We see that a lot through our debt clinics around the state. And, you know, many people think, you know, if I have health insurance, I'm probably not going to get charity care, or I'm not low income enough. If the hospitals charity care policy provides charity care up to 300% of the poverty level, which some of them do. A family of four with a household gross income of $78,000 a year could be covered. So really important to apply. It can apply to costs that even if people are insured, if they're underinsured, it can apply to copays, deductibles, and things not covered by health insurance, or if you're uninsured. So just really, really important to apply. I can't emphasize that enough. So our charity care laws are in our revised Code of Washington. These sites are actually, very easy to read, accessible laws, also through the Washington Administrative Code. That site, WAC 246453, both of these are Googleable. And the charity care policies of all Washington hospitals can be found at this link, which is at the Department of Health website. And that's where you can check to see, how far do they go up in their federal poverty level, coverage of charity care, and their part of the policies. It's just important to know the hospital policies, particularly if you run, if you get a denial, you'll want to go check this website and call Northwest Justice Project. So what's charity care? Charity care is financial assistance that all Washington hospitals must provide to low-income folks who are financially eligible for medically necessary treatment. Not every service you receive in a hospital, even if you're low income, is charity care eligible, but many, many parts of a hospital bill are covered by charity care. The state law, the baseline is free care, hospital-based care for medically necessary services if your income is at or below 100% of the poverty level. That's the baseline our state law requires. And then a discount from that hospital bill is required between 101% and 200% of the poverty level. Now, as I mentioned, some hospitals, particularly in King County, provide free care now up to 300% of the poverty level. So they go well above that floor that state law requires. Someone's assets are not considered if their income is at or below 100% of the federal poverty level. So in terms of how someone will be considered for charity care, you go to the hospital, you get a bill from the hospital, and if you apply for charity care, a hospital is going to try and bill someone else first before they offer you charity care. Is there private insurance that should be billed here? Is the person on Medicaid or Medicare? But as I said, charity care covers both uninsured and underinsured folks who are financially eligible. That's with for copays they can't afford, deductibles, or amounts outside the coverage limits, even if they have insurance. For sure to screen before they send the debt to collections, as you can see here on these screens. And I've already mentioned the federal poverty level standard. So really the screening is about, the hospital debt, whether you're uninsured or underinsured, doesn't matter, you can still get charity care, and whether the qualifying family income, the household income based on family size and poverty level, income including total cash receipts before taxes, so gross income, that can be from salaries, welfare payments, Social Security, and child support. So really just super important to apply. And what we tell folks to do is complete the application. It's now mandatory that it be available on the hospital websites. You can get a hospital to mail it to you, or you might receive it at the hospital if you're in the hospital or leaving the hospital. So a really easy way to do it is, if you're able to access the application, is get it off the website. You want to fill it out, attach documentation of income. That could be pay stubs, tax returns, bank account statement, although I really try not to use those if at all possible. And if none of those, and if someone doesn't have proof of income, proof of benefits, pay stubs, tax returns, or they can actually write a letter and sign it, and that can be documentation of income. Remember, charity care is supposed to be very low barrier. if a hospital, so if you apply, you fill out the application, attach the documentation, make a copy. Really, really important to make a copy of that application. But if you send it in and the hospital calls or writes requesting more information, it's really important to respond immediately and call NJP, call CLEAR if you have questions about what additional information the hospital is asking for. What you don't want to have happen is not listen to your voicemail or open the mail. And I tell my clients all the time, really important to do both. Listen to your voicemail, open the mail, so important rights don't fly out the window because you don't know what's going on. But if the hospital calls or writes and wants more information, call us. If you don't respond, they can mark you as uncooperative in the process of charity care, of making the charity care determination, and deny charity care. So we don't want that to happen, for sure. Collection proceedings, if the bill's gone to collections and you get a collection notice, that collection process can be put on hold while a charity care application is pending, which is a really important, robust right in our fabulous law. So after everything's submitted, the hospital has 14 days to make a charity care eligibility determination. Sometimes it takes longer. It's okay to follow up, and after 14 days, make sure it's being processed, to bird dog the process, not overly so, but it's well within someone's right to call after 14 days and say, hey, did I get charity care? If charity care is denied by the hospital, they have to notify the applicant in writing and the reason for why the application was denied and inform that person of the 30-day appeal rights. Also, collection action continues to be stayed during that appeal process, particularly within the first 14 days of that appeal process. Here's some more information about the appeal process. I would just urge people to call us. They're pretty rare, but it's important to exercise the rights and appeal a wrongful denial, and we would like to help with that. And these are all, these provisions about the appeal process are in the Washington Administrative Code. So a question that there's can be some confusion over, is there a time limit to apply? No, no, no. Someone can apply at any time. It's a really important right in our charity care law. They can even apply after it's gone to collections, after litigation has been filed, even after a judgment has been entered and they're being garnished. You can apply for charity care. It gets more challenging as that process advances, but that right at any time means at any time. So, and we do have clients tell us that they're told sometimes by hospitals it's too late, it's gone to collections. So charity care is an affirmative defense to a debt collection lawsuit. As I mentioned, this is where we see a lot of medical debt cases is at our debt clinics around the state, and folks calling in saying, I was just served with the lawsuit. Really important to respond timely to the lawsuit. Washington Law Help has fabulous publications. One of them is How Do I Answer a Lawsuit for Debt Collection, which has an answer form that folks can use with a checkbox to check, I believe I'm eligible for charity care. That is an affirmative defense to a debt collection lawsuit. Really important to raise and important to respond within 20 days of getting served with that lawsuit, handed the sum of the complaint from the lawsuit. All that's explained in the How Do I Answer a Lawsuit for Debt Collection, including in that form that can just be checked. Also add a publication called Can I Get Charity Care Benefits to Pay for My Hospital Bill on Washington Law Help. There's sample letters that patients can write to debt collection agencies or opposing attorneys to suspend the debt collection process to allow them to apply for charity care. Really, really important, robust right. Again, keep copies of everything you send to the debt collector or the opposing attorney as well, and call NJP. If you're sued, answer the lawsuit timely and apply for charity care as quickly as possible. You do not file the charity care application. As I mentioned before, you want to keep a copy. that whatever you submit to the hospital and bird dog that application, make sure the hospital gets the application. As I mentioned, you want to respond to any follow-up calls about additional information from a hospital. Call Northwest Justice Project if you have any questions about that, for sure. Some folks, the part art, part science of this process can be, should it be the income at the time of service or current income? Some applications ask for both if it's been several years since the date of service and you're just now becoming aware of the debt or the fact that you've been sued. One question we run into is, how do I show my income at the time of service if that's what's being asked in the application? And one way to do that for a service date that's several years prior is if there's no W-2s available or bank statements or pay stubs or proof of benefits. One place to look is the IRS website. They have summaries of income by year if someone filed. So again, these are issues we are happy to help with, and I'm also happy to help consult with all of you who see, I'm sure, a lot of these cases and have a lot of experience working with folks applying for charity care. Happy to troubleshoot any of these issues with you. Once charity care is approved, that lawsuit should be dismissed, and that should be bird dogged also. You want to make sure the lawsuit goes away as it should. One issue we see, when you go to a hospital, you might get the hospital bill that could be 100% covered by charity care, but then you might also get radiology bills, ambulance bills, a provider bill if the person that treated you in the hospital may not be hospital staff, and you might get billed from a separate provider. So what I tell folks to do is just call, if we're at the stage where they're just getting letters and bills from non-hospital providers, call them immediately and ask about a financial assistance application, apply for charity care from the hospital, and then let the non-hospital providers know, hey, look, here's my letter, ABC Hospital gave me 100% charity care. Will you agree to follow the hospital's determination? Same thing applies for if there are medical bills in a lawsuit. If it's gotten to that part of the process, you're being sued and there's a medical bill from a hospital and provider bills in the suit, same thing. You want to call up the provider, see if they'll agree after you suspend the lawsuit, apply for charity care. You want to also contact those non-hospital providers and see if they'd be willing to abide by it. Increasingly, you find they do, or they have their own process. They might say, we don't follow the hospital determination, we have our own process. You want to know about that financial assistance process and apply right away. There's no right to charity care from these non-hospital providers, but I would just put, apply for whatever process they have. If the deadline has passed, you want to make sure to explain, look, I didn't know about your program, I didn't know about the application deadline, I might be limited English proficient or have a disability or medical issues, other compelling reasons. You could throw that in a cover letter and ask them to please consider you for financial assistance at this time. So even after someone's being garnished and the patient, so that garnishment occurs after a judgment is entered in the lawsuit, and the judgment creditor now can garnish a bank account or wages, although certain amounts are both protected from garnishment, though not automatically so in a bank account. But if someone's being garnished for a hospital bill and they apply for charity care and are awarded charity care, the hospital must refund amounts in excess of the amounts owed. So another really important right, it's not too late to apply. If it's a post-judgment process and you're being garnished, really important, give NJP a call or me, email me or call me. I'm happy to consult with you if you're working with clients with this particular challenge. It may be required that a motion to vacate has to be filed. So it can be more challenging after judgment, but it's worth talking it through with an attorney to see what's required. But it's also okay to just go and apply from the hospital. And by all means, if even if amounts have been paid, whether it's through garnishment or voluntary, and that person becomes eligible for charity care after applying, they're entitled to a refund. All right, so some other issues we see. Debt buyers some of you may already know this, but debt buyers are a type of debt collector that buy sort of old debt, not too old to sue on, although sometimes it is too old to sue on, but they buy debt on the secondary financial markets for pennies on the dollar and then sue like crazy, really as an investment vehicle. They're an increasingly bigger part of the debt collection industry. So we see them, they're subject to some new rules after a recent legislative session, and we're holding them to that because often debt buyer lawsuits have way inadequate proof of the debt, of whether they own the debt properly, of the amount owed. So there's some new rules in place to make them provide more information in the lawsuit. Patients with Medicaid coverage getting billed is a big red flag. If you know of clients who are in collections or getting sued for medical debt when they had Medicaid coverage, big red flag, not okay. We have a really terrific pub on Washington Law Help called Billing and Medicaid, parentheses Apple Health, that can walk you through that situation. But in general, it's extremely difficult to even bill someone on Medicaid for a medical bill. There are some exceptions. So some of the changes to medical debt related laws since 2019, we've made some great strides. No more bench warrants related to medical debt can be issued. Prior to 2019, if a judgment was entered in a lawsuit for medical debt, if someone failed to show up at this post-judgment hearing called supplemental proceedings, a bench warrant can issue, and we found in certain parts of the states people were actually going to jail for failing to show up for this hearing, which is horrendous, particularly since many people were getting sued for debts they didn't know because they were charity care eligible. That is no longer possible. Hospitals are now required to give more notice of their charity care program, make the application available in multiple languages in their service area. It's got to be on their website, in their hospital, signs in the hospital. It's got to be on every billing notice, information about charity care. And that notice also has to be provided by debt collectors collecting medical debt as well. Now in our debt collection laws, there's a right folks have to an itemization from a debt collector. If they get a bill from a debt collector and they don't know when the date of service was or if their insurance was billed, they have a right to that. And again, the publication on charity care on Washington Law Help goes through all the information you're entitled to from the debt collector to help you understand what happened in that billing process as well and what charges or credits have been applied since the date of service. Surprise billing is no longer legal for emergency care, and Alice has pulled up a really terrific video. Surprise billing is when someone goes for emergency care, is when they go into a hospital and they believe they're covered and their plan covers in network the services they receive, but there's some out of network provider and suddenly they're surprised after their emergency with a surprise bill from an out of network provider. That is no longer allowed. That's got to be covered as though it were in network.
And Julia, hi there.
Yeah.
I just thought I'd add, and if anybody has questions, use the Q&A box at the bottom. And this is a great opportunity to ask Julia any kind of questions, even things that you may not have occurred. But I'm going to share one that I had, and this was a number of years ago, and I had a big surprise billing. So, and what saved me was that I asked and requested an estimate before I had the actual procedure. So it was a procedure, and so I asked to please send me an estimate of what it was going to cost. But then when I got the bill, it was twice what the estimate was. And of course I choked, like we all would choke. And so these are things that can easily happen. And I say this because if I hadn't asked for the estimate to begin with, I really would not have had any idea what the cost is. You know, it's not like you're shopping for groceries and you have kind of a vague idea what lettuce costs or what an apple or an orange costs. I would have had no idea. But what was interesting about the whole thing, if interesting is the word, it took almost 2 years to resolve it. So when I called and I said, gee, this is twice what my estimate was, and there was silence at the other end. And the individual looked and she goes, I think you were double charged. Well, sure enough, I was, but getting it all resolved took quite some time. And so, feel free, use this time to ask Julia questions. And I said earlier in the beginning, Julia is someone everybody should know. This is something that could impact anybody, not just surprise billings, but just any kind of understanding your medical bills and understanding, what exactly you're paying for. So it's something near and dear to my heart, and so I'm thrilled to have her here.
And one plug, it's just no matter the type of case I'm doing an intake on, I always ask about if someone has any unpaid medical bills. It's such an easy way to help someone and take an enormous amount of debt off their plate and stress off their plate because of our robust state laws. I can't emphasize that enough. So I encourage folks to ask on intake, even if it's not a medical debt related service you're providing or what they're calling about. It's just a great way to provide an enormous service to your clients.
Yeah, that's a good point, Joya, because another thing too is they may have paid it on a credit card.
Right.
And so I always like to ask folks, not just have you had any recent medical debt, or tell me a little bit about tell me about your credit card debt. What are some of the things that are on, and you may find that they paid for medical debt and put it on their credit card. Just to get it out of the way. And so that's something that, correct me if I'm wrong, Julia, but can that be something that if somebody qualifies for charity care, you can use that credit card debt and if you have proof that it was medical debt, can that be considered for charity care?
You mean, can you get a refund?
Yeah.
Yeah, if you've paid the bill and you didn't realize because you didn't apply and the hospital didn't, you can get a refund for anything you don't owe once you've qualified for charity care.
So I want to just be real clear on that because I think that's an important one. So let's say I put $5,000 on my credit card and it was medical debt from an emergency room procedure, and I put it on my credit card. Not knowing that I might qualify for charity care. And then I talked to a counselor and they said, well, gee, I just listened in on this medical debt webinar and I think you might qualify. And so would that be a case where they could apply for charity care and eliminate some of that credit card debt?
Yeah, if they're eligible for charity care, they're entitled to a refund within 30 days of that determination being made.
Wow. Okay. Yeah. So please.
Again, there's it's got to be, not everything that occurs in a hospital is charity care eligible. And there are those outside providers that also bill coincident to a hospital visit. But, if, you know, for those charity care eligible hospital bills, yeah, you're entitled to a refund.
So it's definitely worth asking the question. Tell me a little bit about what's on your credit card. Let's talk about that. And yeah, so that could be huge for an individual.
Absolutely.
So any
And
questions? I don't see any Q&A there, and we have some time. Any medical debt that you've had clients, any medical debt that may be yours individually, and any questions, anything you're hearing out there with COVID-19 and billings that are coming through.
And while we're waiting for questions, I want to point out two really critical websites. Northwest Health Law Advocates, NOLA, has a fabulous website that talks about all kinds of benefits for folks who are documented and undocumented, uninsured, insured. It's a really, really terrific resource for COVID testing and treatment information and coverage. Columbia Legal Services COVID-related benefits guide for undocumented people, another fabulous resource on that covers health insurance, or what health benefits are available, as whether other cash benefits. Just two critical resources that can be really, really useful. So I just wanted to make sure to highlight those. And we have our debt collection clinic in King County. Every Tuesday, it's remote. Here's the information on how folks can call in. Folks don't have to wait till every Tuesday. They can, at other times, just call our front desk and ask to be screened for eligibility and intake. Outside of King County, people can call our clear intake line at the number listed here. Washington Law Help, as I said, has all these publications and so much more. This video was made in 2012, still super applicable and entertaining about the subjects I've covered today. And as a King County Bar Association has a debt and bankruptcy clinic. Unlike Northwest Justice Project, they don't have income eligibility requirements or documentation requirements. They help anyone regardless of income. They have this specialty clinic, the bankruptcy and debt clinic, that's really great. So the website has how to call them for an appointment. And Northwest Consumer Law Center is another great resource for folks as well.
So Julia, we have a question, and there was also a question, will you be able to get the slides after this webinar? And absolutely, you'll get the slides as well as the recording as well. So all of that, we keep all of our webinar or recordings on our YouTube channel. But this is a really good question, and I'm just going to read it. I have a patient, and this individual is a financial counselor at a hospital, and she did not qualify for charity care prior to COVID, but now she does. Can her pre-COVID hospital debts be included in the write-off, or since she didn't qualify at that time, no?
I think she should go ahead and apply. So she worked at the hospital.
No, this is it's a financial counselor at a hospital who had a patient,
right,
and she didn't qualify for charity care prior to COVID, but now she does. Can her pre-COVID hospital debts be included in her write-off, or since she didn't qualify at that time, no?
I think that person should go ahead and apply, and I'd be happy to talk to this counselor or the client. There is a provision for, in the situation which this sounds like, if time of service you're not eligible, but often because of a condition you were seeking treatment for, your income dropped, and COVID being a really recent example of that, your income drops off. There's a reason within 2 years of that bill being incurred, if there's good faith effort to make payments, to reapply again and be covered. So I'd be happy, that person could call Northwest Justice Project or be put in touch with me, and I could talk to them about that. But yes, I would encourage that person to apply.
So great question.
Yes.
Any other questions? I think there's, a lot of uncertainty, especially around COVID-19 and what's paid for and what isn't paid for. And so any questions that you have? Now's a good...
And related to that last question on the NOLA, Northwest Health Law Advocates website, there may be an answer on there as well, because COVID testing and treatment should be covered. And I read on the Office of Insurance Commissioner website that most health plans in Washington are required to cover both testing and treatment. So there's charity care as a fallback, but there's also special guidelines and rules for COVID testing and treatment, which it sounded like that last question was related to.
That's interesting, Julia, because, I sent out with the registration 2 articles that were recently published. One, I think, was in the Seattle Times, talking about they got a surprise COVID bill. So if you go in for testing for COVID and you find that you do have COVID and you're treated, you shouldn't be charged for anything, regardless of your income.
But there's a lot of information on that. I would check the NOLA website, and again, I'm happy to go through it with this person and help consult on this. But the Northwest Health Law Advocates has click-throughs depending on whether you're uninsured or insured, and what the different health plans cover and require. So charity care can be a backup for anyone who could apply, but there's also special rules for COVID testing and treatment being covered, whether you're insured or uninsured. But that website is really, really important to check.
Great. And so you see there, right there on the slide, Northwest Health Law Advocates NOLA, and the link there. Great nonprofit doing great work. So thank you so much. Any other questions? Now's the time. We have Julia right here with us. And so, we got another question. Great. So the question is it possible to get this today's resource information via email? And the answer is absolutely. You'll get everything. You'll get the recording as well as the PowerPoint. And the PowerPoint will have all the resources. So everything that you see here, you'll receive as a follow-up email. And I believe at the beginning of the slide, the presentation, there was Julia's contact information. So I encourage, for the financial counselor who had questions regarding the COVID-19, make sure, do reach out to Julia. Again, I can't say enough that Julia is somebody that everybody should get to know.
Well, there's lots of stuff I don't know, but I work with really great advocates who I'm happy to consult if I can't answer your question, but do reach out by email or call me. And medical debt is something I care deeply about, and as you all do as well. One other tidbit I want to pass on, which a collection agency can't report information about medical debt to a credit bureau for at least 180 days from the date the collection agency received the information about the debt. So that gives a good 6-month window. We just want to encourage clients, patients to apply as quickly as possible for charity care and assert their rights as early as possible.
So I'm looking at the Q&A and the chat, and it looks like we have things coming in on both. So I'm going to do a last call. Any other questions? Again, this material will all be made available to you by email. We also will be sending out not just the PowerPoint, but also the recording of today's webinar. So,
and I don't know if folks are outside of Washington, but everything talked about today applies to Washington State only.
So any last questions? So if not, here I have a question. And the question is, I wonder, and they're just saying, I'm sorry I came in late. I wonder if medical bills have to be in collections only.
To get charity care? No.
Yeah, I don't. So let's see. Could I have the attendee kind of clarify that? Were you referring to a medical bill accessing charity care that it has to go to collections first? And she said yes. And so, yeah, the answer is no. It does not need to go to, and I'll turn it over to you, Julia.
No, it doesn't have to be in collections to get charity care. And the publications listed in the presentation available at washingtonlawhelp.org can talk about how to apply for charity care, and as early as possible is ideal. And hospitals are now required to not just post information about the hospital when you're often sort of distracted when you're in the hospital dealing with your health condition. It's got to be in billing statements. Debt collectors have to make you aware of it. You're entitled to an itemization, but you don't have to be in collections, and we really encourage people to apply for charity care right away the minute they get a bill. And call us at Northwest Justice Project if the patient needs assistance in applying for charity care.
So any other questions? Okay, I don't see any other questions. I want to say thank you so much to Julia for joining us today. This is valuable information. As I said earlier, nearly half of all bankruptcies in the United States are the result of medical debt. So this is huge. And I think with, the current economy and that we're realizing now that we may expect more and more bankruptcies and foreclosures. Regarding foreclosures, Northwest Justice Project also works in that arena as well. We also have, and we publish the Washington State Foreclosure Prevention Guide that's found on our website at everyoneiswelcome.org. So there's a number of different resources that can be really beneficial for many of your clients, many of you or family or friends. And so please stay in touch. If you have questions, feel free to reach out to either myself or to Julia. And thank you so much for joining us today. This will end our presentation.
Thanks, everyone. Thanks, Alice.